application listed annexed railway specified under the specification volume 1 and 2. Notice the Frontier Railway edition corrected date and relevant drawing with such amendment, which may be published from time to time, shall constitute the contract document. This is the concept. There is no mention about the 2014 DCC addendum which has been mentioned, and 2018 letter was not mentioned.
Just a minute, once again read us.
The additional special condition contract along with the article of item approximate quantity standard general condition of contract 2019 and NF Railway standard special condition of 2000 and along with the description list enclosed as annexure and Indian Railway standard specific volume 1 and 2 edition to SSOR schedule that of Northern India Railway 2000 edition corrected up to date relevant drawing shall amendment may be published from time to time. Contract shall constitute contract document and the contractor shall satisfy himself. Then you will come to 2.2. The work shall be executed in conformity with the tender document as a standard general condition of contract 2009. 2.4. Then you will come to 2.35. Next step. What happened in case of any difference?
That is what we asked you on last two occasions.
Yes,
Now we get the answer on third occasion. Yes. Read.
In tender contract in cases, any difference, contradiction, discrepancy with regard to the condition tender contract, specification, drawing, deal of quantity, forming part of tender contract, the following shall be ordered in precedent. First, letter of award, title of item, special condition of contract where specifically said that 46.1 tender condition will be prevailed by law. I will come later on by law. Technical specification as given in the tender document, drawing Indian Railway standard general condition of contract by law, which as I have already said by 2019, that general condition has said it is a tender by law. I will come later on. In a railway in a specification and higher specification. Then you will come to page 45. Next
Railway Act. Huh? Page 43.
43. 2.
Railways Act. 43. Yes.
The rate entered in terms of clause 42 of DCC 2019. I will also point.
Yes.
Next paragraph, my love. In respect of GST also 2009. I will also second paragraph. However, in existing GST contract increase standard date extended clause DCC 2009 and contracted excess rate. Then you will also come to page 47.
Mr. Gogoi, look into the power, constitution of Railway Board, power of Railway Board, and how Railway Board's decision is to be notified under the Act. Where is their authority? To be a binding authority. Railway Board is a statutory authority. Whether they do a notification, keep in their file, will be binding upon a contractor. There must be some procedure when there will be a presumption that contractor knows it. 14 and 18.
To that effect, we are also judgment matter today.
Don't go to the judgment.
Yes, fine.
Go to the Act. What is the purpose of the Act? How Railway Board is created? What is the authority of a Railway Board?
Yes, sir.
And how the decision of the Railway Board is to be published?
It has to be published along with the tender by law because
No, not on that. We are not on the tender. Railway Board is not dealing not only with the tender. Railway Board is given a specific power. In fact, it is a delegated, majority of the power has been delegated to the Railway Board by virtue of the Act. and therefore some power has been delegated to the railway board and they are given to exercise their power by way of issuing notifications, orders, even framing rules. Now, how is that is to be published? Because it should have a notice. That is what we are asking. Judgment will come later on.
It should be published, my lord, and it should be mentioned in the tender, my lord.
Which provision?
I have already stated, my lord.
No, no.
Yes, yes, yes. Yes, my lord.
Which is the provision?
16 months. I am coming, my lord.
Oh,
Otherwise, my lord,
yes.
16.5.
16.5
Yes,
page,
yes, my lord.
page,
Page, my lord, 47.
page 47,
Yes, my
15
lord.
point,
My lord.
16.1,
16.5, my lord. Page 47.
16.5, page,
My lord. Page 47.
page 47. Okay.
If the work commenced specified starting at the subsequent matter, railway consideration stated that due to failure on the part of contractor to comply within stipulated of the agreement, the railway should take action of the contract in terms of clause 62 of DCC 2019.
Hmm.
I want to show, my lord, that
That DCC 2019 applicable. That will, there is no doubt about
my
it.
lord. And there is other also, my lord, and I can
That is not an issue.
Yes, sir.
Issue is that there is no doubt. Mr. Gogoi is also not questioning that DCC 2019 is not applicable. This is the contract. In your special contract also it refers to the GCC. Now, so far relating to the precedents you have shown from the, it is a contract, is not it?
Yes, sir. This is the contract agreement with the
Between us, that is what we asked. That is very relevant,
Yes.
which will have the precedence.
Yes.
Now, there is no dispute that it is the tender value in terms of the contract. Their whole case is that forget about the tender. It is the decision of a railway board. And you are supposed to know, being a tenderer, therefore, irrespective of anything, the decision of the railway board will have a binding precedent because it is a statutory authority and the notification issued and notification issued by the railway board is having a statutory force. So when it is a statutory force or a delegated legislation, kind of a rule frames is a delegated legislation, then you should have a knowledge.
I have put something up for your topic that there is a matter of public type of
Hmm.
that if anything has been taken decision that has been informed to the my lord tenderer before 2 months of tender.
No, that is fine. That is the decision is
They have
taken.
to inform my
But their whole case is that decision statutorily issued notification.
my
Therefore, I am asking what is the power of the railway board? How the
my
notification?
submission before your lordship is that and currently directly connected to that.
Yes, Swazi. Hmm.
That thing has been happened, my because my lord sometimes they have taken some my lord board system,
Hmm.
which is not able to upload in the my lord website. Who is a prudent tenderer, my lord? After going to the terms and condition of the contract and we follow the tender.
Your whole case is that
Yes.
even if there is something, this is a hidden criteria.
It is hidden criteria. How can
We are not
hide
aware of that.
I am not
And
aware of
therefore,
that,
we have
my lord.
offered our
Yes,
price
yes.
on your promise, on your proposal
Yes,
that I will be given
Yes, my lord.
escalation in terms of the contract.
Yes, my lord. এটা একটা উল্টা করেছে তো। My lord, kindly give me this.
Give this book to him. He will not allow his book to be read.
No, my lord, I have highlighted the provision. Lordship has come to the page 27.
Educom,
Yes, my lord. My page 19, my lord.
page,
Sorry, my lord. My lord,
paragraph 19.
6 to GLT 775, paragraph 19, my lord.
Paragraph,
19.
but you have marked a flat somewhere else. 7/7.
775. আপনি so and so, paragraph 19.
Let me first fix the flag.
Even it,
You have not even given the flag. Yes. Educom solutions. Yes.
Mr. So and so,
Paragraph
paragraph 19.
19.
Yes, my lord.
लिख it वहाँ Educom 19. Submission.
I have already given.
Hmm.
Financial and senior counsel appearing on behalf of the petitioner alleges serious deficiency against the decision-making process and a final decision awarding to the contract. It was contended that the authorities have accepted and priority to settle the procedure, methodology, and factor which the temporary proposed to be adopted. Take into the while considering the acceptance or rejection of the must clearly notified in the stated NIT itself. The authority ought to have notified in the tender note itself the procedure they have proposed to adopt evaluating the tender. Such process which does not notify the procedure.
Which paragraph you are reading?
Para 19, ma'am.
Okay. That is a submission, Saurabhji.
I'm coming
Okay.
later on, ma'am.
Okay.
The authorities procedure they propose the evaluating the such procedure does not notify the procedure clause, factor or criteria taken into account the matter, acceptance rejection that the tender cannot be considered as transparent, fair, and open.
You are adopting solely Saurabhji's argument. What is the ratio?
Ratio, my lord, will come, my lord. Then you are looking at page 27, my lord.
Place?
Page 27. Scope of judicial review.
Not page 27. Paragraph.
Paragraph 27.
Okay.
It is well stated. And anybody they accept that the government is not like a private individual who can pick and choose the person whom it deals, but the government is still government when it to enter into a contract. It cannot, without adequate reason, exclude any person from the dealing with arbitrary manner. The state it intends to enter into the contract, it must be too fairly discriminatory nation without unfair procedure. All action must be transparent so as to ensure accountability. Otherwise, it will violate the Article 14 of the Constitution of India. Then your lordship kindly come to the my lord. Page my lord 788, para 41.
788.
Sorry, 788.
88. Paragraph 41.
Yes, my lord. We shall bear the stated principle in mind, proceed to discuss the issue within the judicial review. Parameter lack of liability, transparency, and hidden criteria. I am relying on 42, 43. I am not reading my lord. Main thing I page 45.
45.
What your lordship has said, that is the answer. The ultimate decision award that contract obviously dependent on the scoring hyphen. Nothing prevented the authority to intimate the parties, providing all details as regards the criteria to be adopted in awarding the mark. Have a look at it. Along with the amendment addition made to the NIT. Curiously enough, I later dated 142, the authority merely intimated about the amendment addition made in the NIT, but not about the selection criteria. Here, nothing has been informed by the umpire. In the tender document, tender notice, nothing has been informed by them. Now they are using 2014, my lord, DCC, my lord, where 2019 has been said, addendum, my lord, railway board take a decision in respect of judicial 2014. And one important thing is that, my lord, when DCC 2019 come into force, my lord, that any amendment of 2014 is null and void, my lord. There is no desirable purpose evident as to why crucial information was not made available in spite of the petitioner request to find its estate. Then Dr. Associate has been mentioned, my lord. We reiterate paragraph 46. We reiterate the procedure government follow in adopting tender clearly stated in tender notice. The considered tender received the procedure followed in the matter fair except tender should be transparent fair. Then you all kindly come to the page 49.
Paragraph 49.
Paragraph 49. Paragraph 49, my lord. Yes. Paragraph 49, my lord. In our view, there is a question mark. In our view, if FISAC criteria is not notified at the beginning, then should be made known all the interested before submitting the bid, duly informing them about the proposed criteria to be applied and the methodology in awarding the marks to evaluate technical and Then next is my lord 793, my lord.
Paragraph?
Paragraph, my lord 50, my lord, whether fit the method, not necessary.
Not necessary.
I'm giving this to my lord. I have given all the my lord highlighted the portion in my particular.
But here is a distinction between pre-contract and post-contract. A judicial review pre-tender, pre-contract, and judicial review post entering into a contract.
Right.
Whether that principle can be equally made applicable in case of a tender. There are two phases. One is a tender conditions, violations, and other is a binding contract between two parties.
That is the agreement.
Agreement.
Nothing is
Agreement. So
available.
what will be the standard of judicial review in these both
Yes,
cases? There will be a difference,
Yes, sir.
isn't it?
In agreement, nothing is available, my lord. I have stated that I have shown
Yes, Gogoi.
and my lord, there is a judgment.
Yes, what judgment?
One judgment, my lord,
Yes.
that in respect of my arbitration process available, this petition right, my lord.
Which judgment? Tell us.
2021, 16 SST, my lord.
What is the name of the judgment?
Then the judgment is Unitech Limited and others.
Okay, that we are having. That we are having.
Paragraph, my lord, 39, my lord.
Hmm.
May I read, my lord? 39, my lord. A 2000 band, APL International, mainly there
Not
is
necessary.
APL. And
This
APL,
judgment you need not necessary. We have already dealt with
yes,
it.
well, APL also relied on Srilekha accusation
Vidyarthi.
with that, my lord. Also,
Kumari Srilekha Vidyarthi.
Kumari Srilekha with that. That judgment also I have, my lord. That is the title. And here it is categorically stated, here is the arbitration clause. If Article 14 has been arbitrary exercise of power, then, my lord, it
In this book, the Railway Board Act is not there. Railway Board Act 1905.
Okay.
In this book, it is not there.
What is the how the Railway Board's decision so far relating to an individual contractor? That is vital.
That part
I-
in the 1905 Act, that part is not there. Otherwise, Lordship, it is as part of Article 246 and 7 Schedule, Lordship, they are functioning, Lordship.
Which tell us Railway Board.
Article 246, Lordship,
Hmm.
that is constitution detail. And the 7 Schedule, Lordship, 22, 30 and 89, Lordship. They are functioning, Lordship. Yeah. And in 1905 Act, only it is there, Lordship. Power of the Indian Railways is there, Lordship. It is.
Just a minute. (1905)
No. He is there, Lordship. Section 3, mode of signifying communication from the Railway Board. Lordship.
This is the act.
Lord.
It says,
Lord.
therefore I am saying about the Railways Act.
Lord.
Because Railway Boards Act is only of 3 sections.
Only. Otherwise, in the
It says, central government may by notification in the official gazette invest the Railway Board either absolutely or subject to condition with all any or any of the powers or functions of the central government under the Indian Railways Act 1890. Now, how the decisions made by the central government is to be notified in terms of the Railways Act. That is what we want to know.
that part in the Railways Act, it is silent, Lordship. Otherwise, it is, Lordship, regarding
Which is
That's what-
government decision will be by a gazette notification under
Lordship,
160 central government's power under which provision of constitution?
My lord,
here,
What, my lord?
161,
161?
and 162.
and otherwise,
161 power if the robot or the 163 delegated power.
What is the Railways Act?
Railways Act. Basically,
How
Railways
was
Act,
how was ECC is notified?
CCC of Lordship is not.
How was ECC is notified and modified? Suppose there is a GCC of
Lordship.
2014. It's a
Lordship.
Indian Railway.
Lordship.
Indian Railway is not a company. It is a organ of Union of
That means
India.
it is not-
All contracts are signed in the name of the president.
Lordship.
So what will be the sanctity of a
CCC,
contract entered into by the president of India and a conflict with the railway board?
CCC was Lordship not notified by the Gazette. It's not notified by the Gazette. It's by the Railway Board Lordship. Only circulars they have issued.
We want to know the power.
Lord.
Yes, Mr. Chaudhary, you have to argue that.
That my lord,
That is the basic fundamental argument. There is no dispute on facts.
under Article 162, my lord,
Mm.
there is a delegated power on behalf of president, my lord.
No, that precedent is not. Here your contract is not under 161.
Lord.
That is under the power of president to enter into
Lord.
an
And
union in agreement. What is the provision of
It is there, Lord.
constitution? Mr. Chaudhary, take your seat.
When Lordship, the Ministry of Railways Management Board, Railway Board Management also is silent Lordship. I have just started silent. That part.
Nothing is there.
That part is silent. Even Railways Act Lordship, nowhere my lord will come. They are only claiming part punitive charges and Lordship over wages and untoward incident, that part is there.
The functions are defined in the Railways Act.
Railway.
Those functions are to be performed by the railway board,
Board.
even at all functions are given. Where is that provisions of, because there is a separate provision under the constitution itself, delegating that Union of India should enter into any contract in the name of president. If we go through the contract, there will be special contract, there will be a provision. Where is the special contract?
And I see your lordship have page annexure 1 page.
Earlier, this was the process.
Not protection, state,
Between the President of India acting through the railway administration.
Lord.
So this is an agreement entered into by the President of India. Forget about railway board.
But it is those functions are not very specific here.
We'll find it out. We are here, Mr. Chaudhary.
Lord.
We will go overboard to do work for Mr. Chaudhary and for you too. Gogoi will deliver that arbitration judgment on Friday.
Sure.
That is tomorrow.
Sure.
Means we may require some further deliberation. We have dictated to an extent.
Otherwise also Lordship, my lord, court number 4 has that order was passed. Even Lordship, that was not knowledge before the my lord. In another case, it was brought to the knowledge of the my lord, then my lord has deferred them.
Okay. We'll see. Okay. So therefore tomorrow we have already dictated.
Right.
So certain clarifications will be required from you and other side.
Right.
Just so therefore be ready tomorrow and inform if possible
Right,
to the other side also. So that at some questions we may put.
Otherwise also Lordship, I will also obtain the present status of that case.
Okay.
My lord has deferred after noticing the central railway. When it was passed, it was not before my lord.
So far relating to the first part, that arbitration, we are rejecting that.
I also abandon. Yes,
Okay.
yes, because
No, but
Lordship,
we'll have to, you may abandon,
no.
but in a judicial review, in a contract, we'll have to answer that.
And I have also argued that point, so Lordship have to
We
answer
have,
it.
we'll address that
Lordship has to
and
That was
Lord- and
on that ground only we'll reject. Will not go further. Why should we exercise all this? Let the arbitrator decide.
yes, because Lordship, he has argued that part. I have and so Lordship have to decide that part also, Lordship. Otherwise, Lordship, I'm nothing to say. And regarding Lordship, the function part ministry letter also
Likha.
signed. I have seen Lordship.
Now, coming to the second point. The following facts are undisputed. One, in terms of tender notice 1, 2, 3, in terms of tender notice dated 13/12/2019, the value of tender was 56110418.74. Full stop. Clause 6 of the tender notice declares that 5 price variation clause within bracket PVC is not applicable for tenders having value less than 5 crores. What is this? The chapter 3 of special condition of contract. Is not it, Mr. Chaudhary? Chapter 3 of the special condition of the contract, which deals with price variation and arbitration under clause 1, clause 46.46 capital A point 1 declares that PVC shall be applicable in those contracts where tender conditions specifically permit. Okay. The general condition of contract, where is that?
46 point, my lord, but
Same. The general condition of contract,
this is A1,
46A1
A34.
also declares a perimeteria clause as that too of clause 46A.1 of the special condition of contract. Thus, it is not in dispute that the value of the tender was more than 5 crore, and therefore, in terms of general condition of contract as well as in terms of the tender condition, comma, general condition of contract and special condition of contract, a contract having tender value of more than 5 crore rupees in a contract, comic, the PVC shall be applicable. PVC shall be applicable. PVC shall be applicable. The facts. Next. এটাতে 1, 2, 3 তে থাকিব। Where is that clarification?
Page pala 55 pala
56. 56.
56 is the mala 57 pala.
57.
Yes, sir.
57.
As per item railway board, letter mentioned above, PVC is not
A
applicable.
letter in next thing, in terms of letter number 2017/TRAN trans /01/policy dated 8/2/2018. Under item number 8.0, the PVC clause where is that exactly railway board's decision?
That is page 84.
Page 84.
There,
84, clause 8, কি করলো? The PVC in work contract in accordance with provisions of item 46 capital A of July 2014 it was decided to remove the PVC clause in all work contract tenders having value less than rupees 5 crore. Rupees 5 crore. Next, on the basis of such decision, which was notified by communication dated 8/2/2018, the claim of the petitioner for PVC was rejected. Therefore, next paragraph. Therefore, this court is to decide whether such course of action is arbitrary on the face of the record. As discussed herein above, it is crystal clear that the PVC clause is dependent crystal clear that in terms of the tender in question, tender notice dated so and so, the GCC 2019 and the special condition of contract dated so and so. PVC is applicable. PVC is applicable and shall be dependent on the tender value, not on the contract value. In the case in hand, the tender value was so and so, and the petitioner and the contract value was so and so.
Tender value 5 crore, 10,418. The contract value is 4 crore, 4 crore, 50 lakh, 21,255.25. Page 26 is the tender value, page 31 is contract value.
The notification dated 8/2/2018 was issued on the basis of a policy decision taken by the railway board, in the year 2014. There is no doubt that the railway board is having such power to take such a policy decision. There is also no doubt that the railway board is delegated the functions of the railways under the Railway Act. Railway Act was Railway Act 1898. However, even in the given facts of the present case, 89. From the given facts of the present case and from the annexer 1 annexed to the affidavit in opposition filed by the railways, it is clear that the price variation clause on the basis of which price variation under clause 8 of the notification of the communication dated 8/2/2018 deals with the GCC of 2014 only. GCC of 2014 only. And it is an admitted position that after the year 2014, many GCCs were modified and incorporated, and the contract entered between the petitioner and the railway is based on the GCC 2019. Full stop. The determination and the decision made by the railway board in the year 2014 by suggesting the removal of PVC clause so far relating to the value of less than 5 crore, contract value of less than 5 crores has not been incorporated in the subsequent GCC or the special condition of contract in the special condition of contract. Therefore, it cannot be presumed that in absence of a special condition or declaration, the policy taken by the railway board in the year 2014 shall continue until and unless it is not withdrawn, more particularly for the reason that such policy is not only incorporated in the GCC 2019 and the SCC as well as in the tender document. However, such policy itself relates to a GCC of 2014. Full stop. In view of the above, the determination made by the railway authorities in refusing to grant the benefit of PVC to the petitioner under the contract clause is a result of total non-application of mine and is an arbitrary action. In view of the above, this court shall be within its power of judicial review to interfere with the action of the railway authorities, resulting in the valuable right under Article 14 of the Constitution of India. Accordingly, this writ petition stands allowed.
If you know that
The impugn order dated
dated 1/3/2023.
1/3/2023 stands set aside and passed. Full stop. The competent authorities in railways, more particularly respondent number Respondent number 3 shall now determine the claim of the petitioner as per law and in terms of the contract, taking note of the determination made in this writ
My lord
petition.
may indicate 3 and 4, even Dalpaiguri also necessary, then
Okay, respondent number 3 and
4.
3 and 4
Otherwise, the function closely as per a railway establishment rules.
establishment. Okay,
This
we'll
are-
see that.
Oblige, your lordship.
We'll write all the judgments that to be cited by Mr. Chaudhary. Okay? But you will not get the copy within a week. You will all need corrections and all.
Oblige, your lordship.
Gogo, we have dealt with your part
Lordship,
elaborately.
lordship.
But because we cannot in blind way say that we'll
Lordship.
able, because we have to distinguish in the
Lordship.
given facts of the each case.
Lordship. Oblige, your lordship. Oblige.
If the lordship, the respondent had filed an affidavit, but the copy was served at the earlier set of advocates. So I have just received a copy today.
This is what is the issue here?
It was regarding the GST, GST component, whether it was not accepted. Also, I have got a hold of a document
Hmm.
which will be very important for this. So I may be allowed to file a reply.
Where is the clause?
My lord, I have filed affidavit, my lord. My lord, the thing is that GST was introduced in 2018
Hmm.
and tender is of 2019. So it will be covered and
No, there is a clause specific. I have seen
specific,
it.
my lord,
Lordship,
All taxes-
my affidavit, my lord,
All-
last 2 pages.
All taxes.
I'd like to bring in record this part, just this part is
Ventilation.
the implementation of 2018 notification.
Just let us understand. We may face tomorrow a case. We'll adjourn it. No problem on.
So there are different categories which have been given. I will fall under category D,
Category.
page number 3. Lordship,
Yes.
in cases of all new works to be proposed under GSOI, the state shall prepare schedule of rate after deducting the taxes subsumed under GST.
Mm.
The detailed project report shall be prepared as based on the revised SOR, and the state may add 12% to the cost of the to arrive at the overall cost of the. So this 12% addition, whether it will be this part, I want to bring it through an affidavit and through bidding. That may be allowed.
You want to say that since in terms of this notification, this ought to have been price ought to have been 12% inclusive of 12% GST.
That is 100 rupees. When the price will be given, now when I quoted the price, it is 100 rupees. Now when the bill is paid, now if I take the money, I have to pay 12 rupees. That means 88 rupees. I'll get 88 rupees, 12 rupees. Now since the GST law says that it is the receiver of the goods will pay, so the bill ought to have been 1,12,000. This is what I want to. This is my. I'll bring it to record.
Learned, an affidavit in opposition has been filed by the respondent PWDs. The learned counsel, is it on record?
It is not.
Affidavit on record.
Affidavit.
The learned counsel for the petitioner pressed for a week's time, 2 weeks time.
Because these are old
Okay,
mandates,
okay,
not
okay,
well.
2 weeks time to respond to such affidavit. Prayer is allowed, list after 2 weeks.
Deeply obliged.
What is your contention? A simple widow, admittedly. And the father is not a scheduled caste or scheduled tribe. Isn't it?
Not a STP.
Not an STP. But they claim that since father died at the age of 2 and 6, and they are staying with the mother in their maternal place. In terms of the 2012 judgment, they are entitled for ST. Now, there are certain central government notifications of Ministry of Social Justice and Welfare. Union of India is a party here. This is the difficulty, Mr. Counsel. We waste our time. We'll say now wastage. Some lead counsel will not be here. And there will be no information to us. Why should we adjourn? Yes, argue. Prayer for adjournment stands rejected. What is the facts? Tell us, Mr. Thor. And you are a young counsel, you are not aware of anything. What is the decision?
Indian notice.
Page 60. $65.
65 will start, my lord.
These arrows on somebody's complaint or some admission or something like that.
This arrows out of the complaint, my lord. My
Out
lord
of
will
complaint.
come to the speaking order, my lord.
Hmm.
Page number 65, my lord. My lord, initially what
Any
happened?
stay order?
They came before the Honorable High Court.
Ah.
Honorable High Court directed the state level scrutiny committee
Ah.
to look into the matter.
Madhuri Patil.
Madhuri Patil,
Ah.
that committee, my lord. Then we have gone into it. That is what, my lord, the order starts.
Okay, so Madhuri Patil, in
We
terms
follow.
of committee, consider Madhuri Patil
Patil.
said that nothing doing, no ST.
No, yes.
Now this is under challenge. Any
This is-
stay?
this is state. This is state.
Any stay here in this High Court?
Yes, my lord. There is a stay, my lord. That is speaking order is state, my lord. That is why
Now, speaking order is state means it will be a
this order is state, my lord. That finding of the scrutiny committee is state.
no, there is no stay.
There is two restrictions. That inquiry statement, that police proceeding, my that
Subsequent.
subsequent, my lord, to this, my lord, there is an FIR.
Hmm.
That is
That is a different issue.
That is
FIR is different, but
counter to that they have come now.
so there is no stay as
No,
such regarding
as
the declaration made.
declaration part.
Okay, no issue.
Can wait, my
Under prayer for learned counsel for the petitioner, matter stands adjourned and be listed after 6 weeks. Why? Who are you? Let them come. This virtual is there. You are for whom? Who is as per number 8?
My lord,
What is your role?
my lord, because
No, in this case, what is you filed a complaint?
not them, my lord. There is an accusation against this private respondent that there was sexual harassment conduct.
Is it a subject matter here?
Yes, my lord, because of the fallout of this, that case is this, my lord.
Okay. No date can be fixed. You do virtually. This is not the way on a Thursday. It's injustice to the. Yes, next case. Non-grant of, who is the private respondent?
No, private, other person.
Somebody file complaint.
Yes.
Daughter of the.
Now what is that? There is some act, na?
Yes.
There is a judgment by my Lord Justice M. Chaudhuri. What is that? The other side is not a party. Is it not necessary in this writ petition?
Because there is no objection with regard to the remaining. Only the petitioner is.
I do not know. They ought to have said that yes, we don't have any objections so far relating to this land.
But that is simply sort of.
Mr. Counsel, it is a factual position that there was a suit between two parties. Okay? It is an admission position that there is an injunction. It is an admitted position that the land dispute also between these two parties. And it is also a admitted position that permission is not being granted by the competent authority on the apprehension that there is a civil suit pending. You will clarify that these are not the position, these are not the suit subject matter. They may come and say that no, actually this is also part. Is it not a probable possibility?
Because they have filed a suit saying that there is.
This is your case.
Their case also. We have annexed.
What is the problem in arraying them as a respondent?
Because my lord, here is a case where the GC of to have given the bail permission respect the remaining portion of.
This is not giving because of the civil suit. So let the civil suit party come and we say that where is your suit? This is the area.
No, my lord.
Now what we'll have to determine? We'll have to determine that these two parts are different. Cell permission seeking the cell permission sought not relating to the civil suit.
Yes.
But it's a separate thing. To direct the deputy commissioner to give you a permission, this is the determination we'll have to make.
They keep a hearing.
You only want that.
They can keep a hearing. That will.
Where is the provision? Then why have you come to this court?
No. We have filed representation, but they are doing nothing.
Where is your representation?
My lord,
It's 30.
Huh?
It's 30.
We cannot, in their absence, we cannot determine. That is clear. Yes?
30.
Heard Mr. I. Chaudhuri, learned counsel for the petitioner, also Mr. N. Goswami, learned counsel representing the state respondent. NMS Mahanta or for the standing counsel, revenue and disaster. How many petitioners are there?
Two petitioners.
Who are they?
My lord, one the owner of the land and one the person who started.
The petitioner number 1 is proposing to sell a plot of land to the petitioner number 2. And accordingly, application for such sale permission in terms of extent norm and guideline has been made by the petitioner number 1 and 2. Is it correct? You have already applied for sale permission. However, permission of sale has not been granted by the district administration till date, being aggrieved the present applications. The petitioner apprehends that the deputy commissioner is sitting over the matter for the reason of a pendency of a suit being title suit number
76422.
764/2022 pending before
Senior number 1.
Civil Judge Senior Division number 1 Kamrup Metro Rural Kamrup Metro, instituted by the daughter of the petitioner number 1, inasmuch as an injunction is operating in the aforesaid suit. It is the case of the petitioner that though a suit is pending between the petitioner number 1 and her daughter, however, the subject matter of the suit and the land proposed to be sold by the petitioner number 1 to petitioner number 2 is totally different. First of all, it is submitted by the learned counsel for the petitioner that the land proposed to be sold is not the subject matter of the suit. Full stop. Full stop. Mr. Goswami submits that MS PR Mohanta, learned standing counsel for the revenue department, submits that the service given by the state under composite land sale transfer is covered under the provision of Assam Right to Public Service Act 2012, and a notification has also been issued in terms of the said act prescribing the procedure of such grant of sale permission. In terms of the said act, full stop. Where is the provision of hearing here? In terms of a notification issued on 11th of November 2022 for composite land sale transfer under the Act of 2012, a prescription is made that a prescription for hearing of objection is made, and such hearing is to be taken by the deputy commissioner, additional deputy commissioner. Accordingly, MS Mohanta submits that this matter may be relegated to the competent authority under the Act 2012 and the notification dated 11th of November 2022 for hearing the matter as regards application for sale in question.
Yes, sir.
Full stop.
Yes, sir.
Huh?
Once hearing took place, on 7/10/2023, but objector was not present.
Okay, full stop. At this stage, Mr. Goswami, on instruction from the additional deputy commissioner, submits that in fact a hearing was taken place in terms of the notification dated 11th of November
Not
When-
notification,
uh,
but on the objection.
Was taken place
On 17th,
in as much as the daughter of the petitioner number one has already filed an objection, isn't it?
Yes.
Already filed an objection, objecting such transfer of land. That being the position, the competent authority shall decide the matter in terms of the aforesaid act and extent norms. Full stop. Who was not present?
objector.
Okay. But it could not be taken place for want of the presence of the object. Full stop. Accordingly, the present writ petition is disposed of, directing the respondent number.
This is not a party here, but
Disposed of directing the authorities under the authorities, that is the additional deputy commissioner, authorities under the act, to decide the composite cell transfer application filed by the petitioner in terms of the in terms of the aforesaid act and notification. It is made clear that a reasonable opportunity of being heard be given to the objector, that is the wife, that is the daughter of the respondent number two. Full stop. What is the period of completion of such hearing? There is some prescription. Okay. The act under which provision? The Act 2012. To give us that notification. This is okay. The notification dated 11th of 2022 also prescribes that composite land sale transfer is to be completed within a period of such hearing should be completed in terms of the within the prescribed period as mandated under extant norms. Full stop. Petitions right. Itu kan right, itu kan lagi. Itu. Yes, next.
If in terms of our order dated 6/2/2024, I was directed to object.
Now what to do?
Our affidavit, filed by the respondent number 2,
Hmm.
we have indicated that my lord, the payment already been
To whom?
to the my lord that to the person whose land have been constructed in the
Jogesh Chandra Pal.
Lord.
Now, who is he?
He's a petitioner.
No, his petitioner we know. What is your claim?
My claim is that my land were acquired and I have not been paid the compensation.
Jogesh Chandra Pal. That's why I'm asking Jogesh Chandra Pal.
Lordship. In our
Now,
affidavit,
admittedly, this is it was in the name of Jogesh Chandra Pal.
Lordship, it is the
Now, you have acquired this land. Now, if you have acquired this land, if you pay somebody else,
no, my lord, it is proved that it was acquired and the payment has been made. In our affidavit, we already been stated.
paid to whom? Jogesh
Lord-
Chandra Pal.
Lordship.
Huh?
Lordship, may I kindly see their fair portion.
No, show us that it has been.
In the record, Lordship, only my lord, it is in the my lord that this is not the record, Lordship.
They relied on a Sita
Lordship.
saying that this is our land. Now, this court says you verify it whether it's genuine or not. You have a report which says that yes, it was registered in the name of Jogesh Chandra Pal. Now, under land acquisition case, LA case number something
9/68.
12 bigha 4 lessa,
Lordship.
and in the case of 486 1 bigha 12 lessa.
Lordship.
Total 13 bigha 3 katha 16 lessas has been acquisition from Paul. Now, who will pay this money?
Lordship, I can kindly see my affidavit and
Affidavit?
filed by respondent number 2. ADC dot. And nobody
Space.
cut off. Might be 5. And nectar 1.
Jogesh Chandra Pal, additional affidavit. Now, which affidavit you are saying?
The
about?
affidavit filed by the respondent number 2.
Affidavit
What is the page?
Lordship,
Any index?
Lordship, my kindly see the paragraph number 9.
Affidavit
page
filed by respondent number?
2.
2. Page starts at page 58.
Paragraph number 9, Lordship.
Oh, Brahmaputra board is a party. Central government is a party.
Lordship.
You will say we have paid the money to the deputy commissioner. Paragraph.
Paragraph 9, Lordship.
Okay. If the register can be produced before the court as and when required.
Register.
This is your statement.
Lord.
Meaning thereby he has stated it from the
Register, my
register.
lord, in several times I have been noticed, my lord. Today I did not bring, my lord. It is there, my lord. If required, my lord, I will bring it, Lordship. It is there.
Nothing is there in the register. I have seen it. No signature of Jogesh Pal, nothing. Simply 177 bighas of land acquired and the compensation paid. Normally, what happens?
Compensation to be paid where cash is not paid.
At that time,
No, no.
whether it is cash
At
or
that time also, okay, government
No, no,
transaction
not
never.
I'd
It
like
may
to-
be through treasury.
Would you like to show you something?
even then,
When we take the compensation amount,
Hmm.
so the sample is there. The claimant has to sign,
Uh-huh.
everything is there.
Yes.
But in case the raise is shown to us, like there is no signature of Jogesh Pal, nothing. None of the claimants. In the affidavit, they say there are
I have
177
admitted
bighas.
this, my lord, that in the, my lord, that register, my lord, there is nothing,
Bring the register, we will decide.
Lordship.
Without one thing,
Yes.
Another case is tagged with the disposal case, 135.
Hmm.
These cases, in both these cases,
Hmm.
they were claiming both the petitioners
Hmm.
for online compensation for the same plot of land.
Hmm.
On 4/6, 2014, this was withdrawn. On the ground that they secured relief.
Who are they?
In that case, the petitioner also responded for sake.
Petitioner the main nephew.
From the product, it said that they are getting to get.
Ultimately, they withdrew, but nothing.
Suppose they have been given wrongly.
Look.
Then this may be a collision between the officer and this Ashut. Who knows that? Why should he go to that who has withdrawn? Admitted position is that there is no name of
Look,
Ashut in this Sita.
look.
If you have given to his Ashut to you take your risk.
Not it was frivolous, simply getting the width of the money. They came to this court. They have no right, no title, nothing. Land belongs to Yogesh Pal and subsequently it was
Withdrawn on the ground that they secured relief. Secured relief. 4/6, 40.
Okay, we'll give an investigation. First, pay the money to them, and we'll have an CID or CBI investigation. Who were involved? Maybe when it was paid. Let us see. It's a two concern. One concern is that the citizen should not be deprived of his
That is true, yes.
land without paying compensation. At the same time, public money should not be also wasted.
I will see.
Take down. Take down. The petitioners herein claims that their land measuring
13
13 bighas, 3 kathas and 16 lesas covered by KP Patta number 243, Dag number 1921 and 202 of village Maidamgaon under Mauja Beltala has been acquisition in LA case number 9 of 68.
Yes.
However,
59.
68/69. However, no compensation has been paid till date. This litigation is pending since the year 2012, 15, 2012. Full stop. In the course of argument, the petitioner relied on a document, annexer 20, page 25, annexer,
Annexure 1.
annexer 1 series, page 25.
Annexure 1. Lord.
Annexer 1, page 25. To show that they are the recorded. The petitioners relied on in the course of the petitioners to substantiate their aforesaid claim.
Not there, but
His aforesaid claim relied on certain documents, including annexer relied on annexer 1 at page 25, Sitha copy in support of their claim, and to show that the petitioner is the registered owner of the land and the said land has been acquired from them for construction of River Research Institute. Center, River Research Center. This court, under its order dated under its order dated 6/2/2024, directed the respondents to confirm the veracity of the annexer 1 and fix the method today for such report. When the matter is listed today, Mr. J. Handik, learned government counsel, on instruction from the additional deputy commissioner, Kamrup Metropolitan District, has submitted a certified copy of the annexer, annexer 1, page 25, which goes to show that the annexer 1 is a genuine document. The certified copy clearly reflects that the land in question was registered. The petitioner, land acquisition, clearly reflects that the petitioner was the recorded pattadar of the land in question, and the said land has been acquisition in LA case in the LA case in question and converted into a government land. That being the position, now only question remains is that whether the land acquisition compensation has been paid to the petitioner. First of all, Mr. J. Handik, referring to the affidavit in opposition filed by the respondent number 2, submits that payment has already been made. However, the statement in the affidavit is not clear when, how, and under what, when and in what manner the payment to the petitioner has been paid, inasmuch as, in view of the stand taken by the petitioner that no land acquisition compensation has been paid to them, it is now the responsibility of the collector to substantiate their claim that actually payment was made to the petitioner whose land was acquired. A statement has also been made that the respondent collector shall be able to produce the register to show such proof, accordingly on this matter stands adjourned, and a chance is given to the collector to substantiate their claim that money is actually paid to the registered pattadar, that is Jogesh Chandra Pal. Please this matter on. Now you think of the next course of action. Who will sanction what? Who will pay?
My lord, Deputy Commissioner.
The communication addressed by the additional deputy commissioner. Commissioner. Along with the certified copy of the SITA produced today is kept on record and marked as document A. Be kept on record. Please this matter on. 2012 interest, statutory interest, many things will come now.
District Commissioner won't be.
We'll bring on everybody now. Slowly we'll bring on.
12 years.
This is a continuing mandamus. This will not end here.
12 years
Since
have
you have
already
given us the responsibility to act like reference court, sometimes as a civil court, we are doing everything for the citizens' right. Anyway, when?
after 2 years.
Please this matter on. Give a date. 9th of April.
Well.
Mr. Bora will not take up your case. You want to know the reason? Huh? Reason is the what we'll say, it's the nature of cases we are taking up to 11. We do not want to change the track. We'll take up this matter. We'll take up this matter. Let us go to the other land, Board of Revenue, then what not. We'll go to the, what is your case? That is pay fixation. Pay fixation some other day. You have other cases also. We'll have both because that is almost complete. But the mind is, let me free up.
I'd
Yeah.
just like to take one judgment.
Hmm.
See what happened.
This release your anxiety by first week of April with all these three matters. These two and another one is okay. Give a first week of April. Okay, I'll go through it. I'll give 4th of 5th. In between, we'll try to utilize this 4-5 days vacation, 25, 26. Okay, we'll try. No commitment. 4th of April. Keep. Some portion we have done it, but because of sudden sense. Yes. Auction sale.
Okay.
Your land is sold in auction for
No. Like the land in which
Hmm.
was sold in revenue.
revenue auction.
I have purchased 30 years.
Hmm.
Hereafter, government has filed revenue appeal for it.
Hmm.
Revenue board rejected the prayer for state government.
Hmm.
State government had appealed against the order of revenue. State government it was
Hmm.
who revenue bill was filed. That was
Hmm.
against that order, state government has filed civil.
Hmm.
Before that, civil suit allowed.
Hmm.
Remanded the matter before board of
Hmm.
board of revenue against set aside against that.
Dispute.
After that,
Hmm.
government has acquitted the land from
Okay. That is the auction procedure.
auction.
Hmm.
Hereafter, the original owner
Hmm.
again approached the board of revenue of the country, saying that the revenue sale was made without giving it notice. So revenue sale on this ground alone, 22 as detail was found, and revenue sale was set.
Hmm.
By this time, in this particular case, so I said deeply engaged. But here was the Bhumik was
Hmm.
it's now not coming.
Hmm.
I have traced out the report. I have obtained the civil suit from the honorable.
Hmm.
I have found some fraud by the person who has approached the honorable court after 30. In fact, the then in question was accused in 1959. Thereafter, government has paid him the compensation.
Hmm.
He has accepted the compensation.
Hmm.
After accepting compensation, he has filed an objection that revenue is fixed by the government it was set.
Hmm.
He has filed an application to the land acquisition officer for enhancement of the
Hmm.
compensation. Revenue officer rejected it back, saying that you have to put the revenue
Reference.
reference. Thereafter, he was filed. After acquisition the land from me, he has approved again the board of revenue.
So there may be two part. Again, how it was acquired?
Because government has, by this time, the land has not been transferred to the government. Land has
You purchase it subsequent to the auction. No, subsequent to the acquisition from him.
been acquired.
Okay. So there was an acquisition, but in fact, land was not taken over by the government. But there was a second land acquisition.
Been taken.
In second land acquisition, you have been paid the compensation. But they say that there was a first because you purchased in the auction sale. Are you having these facts on record, or you want to bring something on the who is
We have stated, we have had additional affidavit
okay?
stating that
Hmm.
we'll bring on record the document. We have bring on record the document. We have obtained the certified copy of the Honorable High Court with petition, copy of the petition.
Hmm.
We take the legal office Honorable Court to produce the copy of the petition because it will become a bulk.
Okay.
We have the certified copy.
We can call that record also along with this.
Lordship can call the record.
Hmm.
And before that, Lordship can see how they have received the compensation. I have collected the copy, how they have received the compensation.
Who is for a private respondent?
He's avoiding. He has accepted the compensation. Notification is taken
How
note.
government has acquisition a land twice?
That is, so the government has challenged by revenue tax.
Okay.
That becomes final.
Ah.
Because that becomes already
No, that we understand. According to you, I have become an owner by virtue of a
revenue.
revenue auction. That was challenged by the state, that was affirmed. Then it was remanded back by this High Court on a challenge. Again, it was dismissed. Matter ended. Government's appeal has attained finality.
Hereafter, government has taken
That is fine.
I do.
Again, the second time acquisition. Same land.
Yeah.
For what purpose?
for
You have got the land also, payment also,
wait, okay.
that land acquisition compensation. Now, what will you decide?
Lordship will decide regarding the revenue appeal. Because this revenue appeal, I have
Ah.
challenged the revenue appeal order.
Land is vested with the government,
now.
in whosoever name, it's not a problem. Moment notices issued under the Land Acquisition Act, it is vested in the government. Now, what will you decide?
No. Lordship will not go to that matter. I want to say only,
This is within our knowledge now.
I have to produce because I am appearing.
You are correct. You are
I
correct.
have to express. I cannot.
Suppose we set aside this order of the Board of Revenue and the, suppose assuming for a moment, Board of Revenue. So therefore, your sale remains.
They not remain. We can comment that.
That's why.
Okay.
Either way, nothing is to be this land belongs to government.
Government.
Who purchase in auction, who has not purchased in auction, no relevance.
Nothing.
So
Now
it has become infructuous.
No. Otherwise, if it is not set aside, the
Ah.
report order is not set aside,
Ah.
because they have concealed the fact with the revenue court.
Hmm.
They have concealed the fact that they have received the compensation,
Hmm.
and they have come to the court after 32 years, concealing all the facts
Hmm.
that land they have received the compensation from the government,
Hmm.
and these are the money received. They have received the amount by check.
Hmm.
I have collected all this.
So therefore, we'll close with all these facts recorded. That these are the facts, therefore nothing survives. No, everybody has got their relief.
No. If revenue board, if they will file a case against us or against government
Hmm.
again, claiming compensation for the next auction, next revenue sale, land acquisition proceeding. That is their claim. If that is not set aside, further litigation will come.
Okay, you give the facts in affidavit or in a way.
I have already filed an affidavit.
Okay,
I have already filed an affidavit to bring on record the additional fact.
none appears for the others.
None.
Who is the counsel?
PM Singh, DM Thakuria.
Hmm?
DM Thakuria.
What is the Board of Revenue's order?
Court of Revenue's order is signed. Page 32. Look.
Record has come.
Record of the Board of
In fact,
Revenue.
We have been asked to produce the record,
Ah.
but already the all records are not available with the Deputy Commissioner Office. So we have written to the Revenue Board to provide it. So
But in Revenue Board's record, Revenue Board's record is
Revenue
there.
record has come. Look.
But nothing is there.
Nothing is regarding look at the original.
Original, nothing is there. How it was auctioned, where is the notice, nothing is
No,
there.
that
On
is-
what basis Revenue Board has taken a decision?
That is in the writ petition itself. I have obtained a certified copy of the writ petition. That is in the writ petition itself. So you can see the writ petition WPC number 843. Got it? WPC number 843.
Sale case number 508 1970-71 is there.
Now that is the different subsequent case. Earlier revenue sale case number 714 of 68.
What is 508? Why this court wanted 508?
508 is Page 29.
Page 39
Five
of
zero is Lordship, regarding the Lordship, Lordship will find at page 28.
page 20 of the petition.
Look, page 28.
What is that?
That is the land sale case number 50 of 7071. That is Lordship, the I have purchased.
Page 20.
Page 28. The judgment is rejected.
So that is not that is not available or what? Borua?
No.
You have the instruction.
Yes. Lordship will find the petition. Yeah, I have obtained a certified copy. Where Lordship will find. Lordship is taking 843 or
I'm just taking it 843.
843.
Hmm.
I will take your Lordship to the page number 3.
Hmm.
Lordship, what?
Hmm.
Now, para 5. Petitioner beg to state that this is state government.
Paragraph 5.
Para 5.
Yeah.
Petitioner beg to state that the Holodro Chaudhary was the owner of the aforesaid land. Submitted opposition before a land acquisition officer Guwahati.
So Holadhar is the respondent here.
Holodro's father.
Hmm.
of the respondent.
Oh,
Regarding assessment of hedu of the state, then ultimately price of the land is covered by KP Patra number 247 at rupees a month, and Patra number 247 at fixed at rupees 14,805, and Patra number 26 was fixed at rupees 38,0110. State officer, and the entire amount was received by the recorded Patra, respondent number 6 in land acquisition case number in 1957-58. So that is already on the record. Government is aware that fact. But in the land acquisition case, also, the government has not settled all these things. In the revenue effect.
your land sale case number was?
My land sale case number.
Hmm.
Five 7071. Dated 3373. There are two sale cases. One is 508, one is 714.
With the land acquired in the year 1957-58 was sold in land sale case number 714 of 6869.
and 508 of 7070.
Where is that?
But it's fine.
No, that written as analogous case, but this their case is that this land sale of the said land of Doug number, patta number 247. KP patta number 2, what is your Doug number?
166.
So, KP patta number 247 was acquired.
Patta number two patta has been acquired, 247 and 166.
Where do we get that?
Lordship will find
Hmm.
at page 28,
Page 28 of
repetition.
repetition means this 843
Main repetition. Today's
page.
page 28.
Okay.
Para 6.
Hmm.
Before that, 508
This is the
Therefore-
common judgment
common sense.
against
Against state government
130 RA and 129 RA. One as request to the government preferred
against two revenue sales.
against two revenue sales.
Two revenue bill was preferred.
We want a record of this case. There, this order will be clear. How can we get this? Because according to the state, land sale case 17714 was challenged in 130 RAK 82.
Yes.
Isn't it?
Yes.
Where is that 130 RAK 2 order? That you have said.
That is page 26 itself. It is
2070 130 RAK. This is.
and 129. Both are common sense.
Now they are not dealing with the other appeal, that is 129. According to them in the writ petition, land acquired involves the sale case number 714 and
508.
their appeal.
508.
Huh?
And 508.
No, they have not said. So as the writ petition.
Lordship will kindly see page 26.
No, that is the findings of the Board of Revenue.
Okay.
We are not on there.
Okay.
We are on the case of the state.
Lordship.
State
Okay.
case is that this was a land acquired in such and such year for PWD.
Okay.
While PWD was there, somebody tried to encroach this land.
Okay.
And then we found out that this land we acquired in 1956 or 57, subsequently it was sold in auction. Therefore, we have challenged that in 120, 130.
Lordship will find
Now, listen to this case, 129. Therefore, their case is that our appeal was taken along with 130. Now we want to know what is the 130 as per the government, not as per the Board of Revenue decision.
Lordship will find
What is 130?
Lordship will find
Hmm.
What
is the description of 130?
page 19. Page 19 is the page 19. Certified copy of the Jamabandi of Pata Moja. Lordship will find Pata number 41 130 old 166 new. Pata address name Bhubaneswari Devi, wife of Sarat Goswami. And Gadadhar Bhuyan, he is the father of the present respondent. And 14 Deka in rating. And the Gadadhar Bhuyan Krakov and the 14 Krakov. As per order passed skill case number iman communicated by the iman entire land of pattern number 5 figure 3 kota 13 research mutual in the name of passenger Dementon of the present. As per order dated iman circle officer mutation case number iman is mutual in the name of Pokindronath Deka by inheritance from Dementon Deka. Now Lordship, I will take your Lordship to the letter to the government advocate page 22.
What is your patta number?
My pattern number is
166.
166.
Bhuvaneshwari Devi.
Bhubaneswar TP and Godadar. Because total land is 5 biga, out of it Godadar has only 1 biga.
Who is Devendranath Deka?
Petitioner's father.
Hmm?
Petitioner's father. Basically, revenue board allowed the appeal on the grounds that no notice was served to him. He has said that revenue board has allowed the revenue.
What is the finding of the revenue board so far relating to the acquisition of the land for PWD?
Regarding the present case,
Ah,
before the board of revenue,
ah.
nothing has been. Lord to find a page 45, the judgment of board of revenue.
Yes.
Page 45. Here, the record on the lease. Page 48. Earlier, it was considered as lease.
Yes.
Page 48, last paragraph. Last paragraph. There will be a lease deed between the partner and PWD, but there is no such lease deed, and submitting all relevant documents with the department concerned is necessary. Actually, there was no lease deed. If the lease is for deposit to title deed is not necessary. In case of equitable mortgage, these are recorded. And there is recording only that in case of PWD asserted that bequeathed land has already been acquired by Government of Assam by functioning Office of Executive Division of PWD not approved division. Present respondent further was implicated as a respondent in RA 129 of 82. In that case, respondent repeatedly wanted to know about the land acquisition case number stated by PWD. Revenue appeal before the board of was dismissed, and PWD failed file civil rule number 843 of 93 before High Court. Honorable High Court remanded the matter of the board with discretion to the PWD will be laid down. All relevant documents of
What is the order of the High Court remanding?
document fine.
High Court order.
Annex 8. It is not annex 6. I have the copy. Page 26 it has been recorded.
Hmm?
In page 26, High Court order is recorded. In state government appeal document is recorded. Page 26. In course of hearing petitioner, the learned counsel for the state, got it.
No.
Page 26.
Page 26 of what?
Page 26 of the present.
No, we want a copy. High
Copy,
Court
I have-
order.
I will give you a copy.
You bring on this on record. See, if apparently it seems that land was acquired for PWD, but name was not changed. Names were not corrected.
Correct.
Therefore, when land was acquired, compensations were given. They did not pay the land revenue. So therefore, there was an auction. In the auction, you have purchased it. Now, when you have purchased it, thereafter again the land acquisition, you have
Now, after lordship, they have government has filed appeal against the revenue auction
Hmm.
and writ petition. After remand, after dismissal, they have ended. Thereafter, take this.
they thought that instead of fighting, let us once again acquire. So they have acquired the land. Now you got the compensation in terms of the
Execution.
in terms of your right under sale.
Sale.
Now if the sale goes, your right to receive compensation will also go. This is the case.
And he will claim the compensation again.
Okay, we'll record everything and we'll say that there cannot be any aggrieved party. Land is vested in the PWD. Give us that PWD acquisition. Who will give? Hard. Okay, we'll pass the order at 2. Specific so that on the next date we get some instruction from you. That a report from the circle officer, what is what will go
They
on
have
that.
no record.
Huh?
I have started. They have no record. That is why they are not put.
Okay, we'll pass an order.
Here, because the state has demanded the matter, the High Court has demanded. So,
Where is the order on the point of delay?
so the High Court order.
No, not High Court order, that impugn order. That starts at page 26.
That order start from present order start from page 45.
Page
45.
45. How the delay is dealt with?
They has been dealt with or to be fine.
Government's appeal was dismissed and the private respondent's appeal was allowed.
After that, tweet,
When the government's appeal was decided,
government appeal was decided after remand.
first it was allowed. First it was
First, it was dismissed by the board of government. It was dismissed. Appeal was dismissed.
okay.
Against that order, state have had it reviewed in High Court.
Ah.
High Court by judgment
Ah.
dated 1979
Hmm.
framed some points
And
and remanded him at the board of appeal.
again it was dismissed.
Again, it was
So against that attained finality.
Finality.
Thereafter, when that after remand, when this order was passed, date
17/11/2023.
17/11/2003. Then when this appeal was preferred by the other person,
Other person preferred appeal in 2006.
2006. Okay, you give a list of dates. We'll decide this matter on Monday. Enough is enough.
And-
2013.
And regarding lordship demand matter, have given the High Court order.
Hmm.
That could send it to the High Court order.
No, not today. You just give all the sequence of dates of events and the delay. On the point of delay, we'll close it. Will not go to anything.
Because already a lordship is inquired.
Hmm.
That has been discussed in the High Court.
That is why. That's why you just from the High Court's order, I am taking it. Are you having a copy? Give a list of dates, concluding when it was auction was done. The facts, what you have submitted a little while ago. Give that. Okay. And the point of delay. When it was taken and when the appeal was preferred and when. This is one appeal or two?
No, one.
One. What is this? It agar file dispose of. Okay. Release this matter on Monday. Monday, Tuesday.
Lordship, can I take back the
You want to take back? Okay.
documents?
Uh,
If lordship wants to see these documents, lordship can keep it. Otherwise, lordship, it may be lost on the file.
Tuesday, you give a if possible, give a
Certified
copy. Not
Just
you give a Xerox copy to us of all these documents.
I have them.
You have to give a copy.
Okay.
Keep this copy here so that we can come prepared and decide all these facts. Please keep. Itu kuntu itu agak tu na itu silo.
That is, I have given regarding the acquisition by the government and payment of revenue.
Okay, we'll keep this also. Give a copy.
I will photocopy.
Good evening, Faraj. Yes, Tuesday.
Because I guess the party of
Better revenue board. Order passed by Board of Revenue.
debit. That is the page 20,
Page
20,
20.
20 of 2G. And I said, but not 20, I got 22. And I said, what happened, my lord? The number 4 had stated out of 10. What was that? If party to
Okay, but just tell us the facts.
claiming party to that's why it was the at either petition or party to the plan of one quota that is covered by tag number 47904
One katha,
new
one katha covered by
tag number 47904 924
4792
924
old,
and 4795 new
4795 new.
of quota number 90 old and 253 and
Okay,
in product out.
Hmm.
And what happened, my lord, when he filed this application?
what is her case?
Okay,
This is by Ranu Bora.
Ranupura. That case was filed by the Ranupura is the wife of the Prafulla of dead Prafulla of Pura. He has inherited the land from her after the exile of his father. Her has been mutated in place of expired child.
Any application for by Ranu Bora? Where is that?
Yes, my lord, that application is not here, my lord.
Page 27 or what?
No, my lord, what happened, my lord? I have annexed the order, initial order, which has been rejected by the Deputy Commissioner, Additional Deputy Commissioner Zuhat for her partition care.
Where is that?
That is lordship will find at page 20 annex 3.
Page
20 annex 3. I am reading this very small page order. I am reading that. This order was passed on 10/5/2010. Here put up today, peruse the case record in the picture filed by the Secretary Ranu Bora, wife of dead Prafulla Bora, saying to partition her share of land one quota covered by 12 tag number 12 of number 2 block over Mahal Moja. Notice where served to the quota. Both of the parties submitted written statements and documents with the evidence. The petitioner submitted that it was her husband's ancestral property and she is paying for 0 bigha 1 quota 0 lesser. So she is entitled for 1 quota of land as share among 5 brothers of the state father. While posing as necessary, she admitted that she has no possession over the land. The OP submitted in their statement that the petitioner has no share in the quota as she has sold her share to different parties and she has no possession over the land. The municipal holding number 166 in under land and that belongs to late Lokidhar Bora, father of Sri Satendra Nath Bora. OP has submitted a revenue receipt for 50 number so and holding number 166 in the name of Lokidhar Bora, who is uncle of OP. The petitioner, on the other hand, submitted
Okay, partition was not granted.
then he approached the revenue board by filing an appeal, case number 69 RSZ 2010.
What is the decision there?
This one is that my lord directed to partition the land which he has paid. In this regard, my lord, this was expert. Accident
First expertise.
expert. What happened, my lord? Notice was good, not served upfront. And thereafter, my lord, what happened, my lord? The paper publication has been done. It was in the paper publication, and accordingly, my lord, this order has been passed without our presence. This is my present, my lord. After that, my lord, after passing this order, my lord, the office of the Deputy Commissioner Zulfa has issued the notice to the other respondent. I am reading the interim order, my lord, with the relevant portion that is started at page 24, the findings of the revenue board. That is at page 24.
Page 24.
Page 24, after date, here for date. We have heard appellate side only since the respondent have not appeared despite publication of the notice in the newspaper. After hearing and proper perusal of materials on record, that record means the file that has been filed by the private respondent. At the time of the hearing, during the pendency of the revenue appeal file, no lower court record was called for. And
Just a minute. Just a minute. What is the ground of challenge?
pendency no service has been supposed to be started. So, here the
What is the record? Record.
record is not called for. Record
We do not want to remand it back. This is a matter of 2013 of Board of Revenue.
40
And the order of the circle officer is 2010. Who is in possession?
have been put.
If you are possession, be in possession.
Yes, so that is I have added to an extra record is
Record is not available.
an extra 6
Annexer 6 page.
page 23. After passing this order, the office of the Deputy Commissioner
Page 20.
29 physical photo services circle officer At my here it is clearly stated that the holding number is another. And what they have said, their holding number claiming in the additional affidavit, but their holding number is separate.
This is not a revenue dispute.
Basically, my lord,
This is a civil dispute.
this is a civil.
Yes,
dispute.
This
Now,
is
my
a
lord,
civil dispute. You say that he has not inherited, she is having mutation. You say you are in possession, report says you are in possession, she says she is not in possession.
Civil court can-
You go to the civil court.
in fact, my lord, if I can
Yes,
clarify, my lord,
exactly.
what their ground of challenge is that this is an order which has been passed by court. There was a newspaper
Expert
It cannot newspaper
publication is there.
publication.
But okay, fine, if there is a grievance, newspaper is, we do not accept it to
Madam,
pay
please
proper
answer.
publication.
My lord,
Reason for-
even if I accept that,
Uh.
the contention of the respond number 4 is that our predecessor, my father-in-law, and the petitioner's father, they were brothers, and that has not been denied. In their affidavit in reply, they have not denied that.
The problem is that in a writ proceeding, we'll decide either the
The correctness of
whether he is entitled for a hearing.
the correctness of the order.
This is one, and suppose we say that, okay, let him have a chance and remand it back to the Board of Revenue.
Right.
That is one aspect. Other aspect, if okay, it is decided on merit, let us look into the merit.
Right.
And we do not find
Even-
any serious illegality
On the part
or
of the
error on the judgment
Yes.
passed by the Board of Revenue.
In-
That being the position, we would not may not like to remand this matter to the, because we'll go by their affidavit and we'll reject their contention. If we go into the merit, okay, this is not a proper service. A person's right over a land is been negated. More so when initially the original authority has rejected your content. That's fine. We can remand it back. What do you say?
if your lordship kindly take up case 24, the
Hmm.
findings of the revenue board, my lord, is based on the record that the mutation of the respond number 4 by way of inheritance was done in 2005. They,
That's why
That was
to
challenged.
affirm this judgment, we'll have to see the
my lord, and
record.
my lord, that was challenged by the petitioner before the ADC. ADC upheld the mutation order, and that order has not been challenged any.
That we
So
have
that
seen.
has attained finality.
That we have seen. The Board of Revenue's concern is that she already over the plot of land, there is a mutation.
There is a
That mutation was challenged by him, that was negated.
negated.
So therefore mutation remains.
Remains.
If mutation remains,
Then
where
there's
is
no
the question of
denying party.
denying partition? That is the issue. And
Because-
court says, what is the condition for partition, granting partition? Which provision? What are the conditions that partition can be granted
Well,
under Assam Land and Revenue Regulation? After hearing the learned counsel for the parties for some time, this court is of the opinion that the records will be in the deputy commissioner. Because already order was communicated, partition was,
was direct.
what to do? Where is the record?
At the time of the writing of the revenue code, the record was
No, but it
Section
seems,
97 deals with
Huh?
the section 97.
some LN.
97 provides the qualification who can ask for a partition.
Volume, which one? This is a big, keep the big.
Regulation
97.
right. Chapter 6.
Every recorded of a permanently settled estate and every recorded landholder of a temporarily settled estate may, if he is in actual possession of the interest in respect of which he desires, partition claim perfect or imperfect portion of the estate, provided that no person shall be entitled to apply for partition. If the result of such partition would be to form a separate estate, liable for an annual amount of revenue less than 5 rupees, no person shall be entitled to apply for imperfect partition of an estate unless with the consent of the recorded post-bearer holding in an aggregate more than one half of the estate. A person may claim partition only insofar as the partition can be effected in accordance with the provisions of this chapter. Now, my lord, the respondent number 4's husband, already there was a patta issued in his favor. And that patta is also not valid.
He is not important. If he
And my
realizes
lord,
whether he is in actual
Who is in
possession of
position? Tell us, out of the court.
my lord,
Who is in position?
we have a residential house over there. We are paying
That-
land revenue.
my lord, that house, that holding number is separate, my holding number is separate.
You are still in position.
Yes, my lord.
To fight out in the civil court.
Yes,
Yes,
my lord.
yes.
Huh?
My lord,
Because basically basically they are denying my title, my lord.
Eviction should, and it is
And when this, my lord, the mutation was done, it was based on actual possession.
Heard. Mr. D. Borua, learned counsel for the petitioner. And you are for?
My lord, I'm for
Respond
respondent number 4.
Respondent number 4. The petitioner challenged the judgment dated 14/6/2013 passed in case number 69 RA within bracket J/2010, whereby appeal preferred by the respondent number 4 was allowed and perfect partition of the land claimed by the respondent was granted. Earlier to that, the additional deputy commissioner Jorhat, additional deputy commissioner Jorhat in PP case number 181/05-06 preferred by the present petitioner. Respondent number 4 was dismissed under order dated 10/5/2010, rejecting the claim of the respondent number 4 for partition on the ground that she was not in possession of the land covered by DAG number 4795, PP number 253, measuring 1 katha in what Mauza?
town.
Block number 2, Jorhat. Full stop. The challenge to the notice, the challenge to the decision is primarily on two counts. Firstly, on the ground that the petitioner was not properly served notice and the decision taken was an expert decision. Secondly, the full stop. Secondly, on merit, more particularly on the ground that the Board of Revenue could not have concluded that the respondent number 4 was in possession and that possession is not a prerequisite for grant of partition, in as much as Rule 90, regulation, section 97 of the Assam Land and Revenue Regulation prescribes a condition precedent, a condition of possession to grant a partition. Full stop. The case of the petitioner, case of the respondent number 4 is that, where is your application? Have you filed with the affidavit? Certificate copy of? Okay.
This is the memo.
A certified copy of the memo of appeal preferred by the respondent number 1 is produced before. Respondent number 4 is produced before this court. Complaint, the application for partition is also part of such record. Where is that?
Memo of appeal is not a part of the record, only the judgment has been.
Okay, not there.
What people find page 22 first paragraph. That was
Mhm.
the contention of the respondent number.
Okay. It is the case of the respondent number 4 that the respondent number 4, after date of her husband, namely Prafulla Chandra Bora, took absolute possession and inherited the land in question, and she got her name mutated in respect of the said plot of land in the Jamabandi by an order dated 1872 got mutated. Full stop. However, such order of mutation was challenged by the present petitioners before the additional deputy commissioner, which was dismissed by the additional deputy commissioner. Such fact is not under dispute.
It is not.
Such fact is not under dispute. Such fact is not under dispute. The learned, where is the deputy commissioner? That is partition, order of partition. Yes.
The revenue board order, page 25.
No, that
That is 20.
Oh, that is
20,
page
answer
20.
base
Page 20. Rejection order of it.
rejection order. The order challenged before the Board of Revenue. Page 20.
Page 20 of the review.
Of my petition.
The order dated 10/5/2010, by which the learned additional deputy commissioner Jorhat declined to grant partition to the respondent number 4, has recorded that the respondent number 4 had no possession on the land in question, and in want of possession, the land in want of possession, the partition cannot be granted. Full stop. Full stop. While dealing with such order, the learned Board of Revenue concluded that as the appellant got mutation order in respect of her inherited property, and her mutation or respondent number 4's mutation order was also confirmed by ADC, and the challenge to such mutation being negated, the respondent number 4 slash appellant was entitled for partition of her mutated land. In terms of section 97 of the Assam Land and Revenue Regulation 1886, uh, to grant a partition, the following conditions are required to be considered and also required to be established. One, the person seeking must be a record must be a recorded settlement holder and landholder. Two, the respondent must the applicant must be in actual possession of the interest in respect of which the partition in respect of the land in which partition is sought for. First, the next, such partition cannot be granted if the same results in partition such partition result in formation of a separate state if such partition results in formation of a separate state and resulting in payment of revenue less than 5 rupees. Now it is, I think this is okay anyway. Revenue within certain limit, not 5 rupees. A person is also not entitled to apply for imperfect partition of an estate unless consent of the recorded co-sharers holding in the aggregate more than 1/2 of the estate are given. The application is not there. What should the area? How the Board of Revenue decide give partition? What partition? Against
Partition
what?
in respect of the application was for 1 katha of land. Our inheritance was 2 katha by way of inheritance. But look, if your lordship allow
We'll
me,
remand it.
may I just-
We'll remand it to the authority.
Well,
Do it properly. This Board of Revenue's order is also not. It cannot be.
Well,
Here's a partition. No partition is required. Give partition. Against what?
basically, the Board of Revenue has decided, my lord, what would be the condition for, because the possession. And if your lordship, my lord, will kindly see section 41 of the Regulation Act. When there is an entry in the record of rights, it is always presumed to be correct and it
No,
is
that
done
we-
with the actual possession.
That we understand.
So that then Revenue Board has taken note of that mutation, my lord. In
No,
2005.
there is an object of partition and mutation.
No, what in
Uh,
what context I am
Two
submitting?
different issues. Suppose there is because the object, another object is that there should not be any there should not be more fragmentation to the smaller states.
True.
Isn't it?
That is what the disqualification.
So what should be the two kathas of land? What should be the fragmentation? Because
That
partition will mean a separate issuance
In
of
fact, revenue
issuance of a
board-
patta, separate
when
settlement.
revenue board has remanded back it to the authorities to do the partition. Here the only right of partition has been adjudicated. My lord, if your lordship kindly see section 41 for a moment.
Hmm.
My lord, the
The
finding
presumption is there.
Yes. and the mutation of 2005 having
How
it in
can Board
final,
of Revenue say that there is no requirement of possession?
requirement of possession, my lord, it is there.
Huh?
Requirement of
It
possession.
is there.
Yeah, it is.
We'll have to affirm it.
Yes.
Board of Revenue to be correct.
In fact, my lord,
Then it will become law that possession is not required
No, no.
against the
page
against the statute.
24, the findings of the revenue board is on the basis of possession, my lord.
That possession is correct, but that finding will have to interfere that portion.
My lord.
You go to the civil court. This is not the case. Both of
Basic-
you. Basically, you are claiming the possession.
I am claiming partition, my lord. Here, they are denying my title.
It is also seen from the record that though the respondent number 4 is claiming the partition on the basis of inheritance and possession. However, the right of the respondent number 4 itself is denied by the
Petition.
petitioner, which is clearly reflected from the order dated 10/5/10 10/5/10 of the 10/5/10 passed by the additional deputy commissioner in PP case 181/2005/2006. During the course of argument also, both the learned counsel for the parties has asserted their possession over the land.
Report does not say.
Huh?
Last one, the report does not say.
No, there are contrary report of the circle officer
Okay.
who says my position.
Okay. Full stop. Though the learned Board of Revenue has concluded that since there is already a order of mutation, that there is a presumption in favor of the respondent number 4 that it is having the possession. At the same time, from the order of the additional deputy commissioner dated 10/5/2010, it is reflect that the report of the circuit officer discloses that the respondent number 4 is not in possession of the disputed land. Not in the disputed land. A copy of a report. Where is that report?
That is at page 29.
Copy next 6.
Page 29.
Page 29, my lord, it's the report of the last Mondal.
Subsequently.
Mondal. In the reply,
Partition granted in terms of this order.
no, it was after this order, after the revenue board order. This last Mondal submitted a report, which we have disputed in our affidavit that the last Mondal and the petitioner has taken the
No,
respondent
it's fine, but any stay in this not to grant partition.
there is a stay of it.
Stay.
There is a stay of it.
So therefore, we will not go to all this.
And there is two circle officers report which confirms my possession, which was taken on note by the revenue board.
Now propose us what to do. Send
My lord, if your
it
lordship
to, send it to the
section 100, my lord, when there is a question of title, the deputy commissioner ought to have referred the parties for to the
that is what
that was what ought to have-
that ought to have been done.
Done.
They have to file an eviction suit. If they
no,
are at
no, that's not.
This is not the issue.
That-
Who is claiming partition and possession? She's claiming.
I'm in
She's not having partition. You are in possession.
Yes.
Then she will have to go to the civil
Yes.
court. That's all.
And they are disputing my title.
And if you are disputing their title,
Will kindly have a look at section 100 for a minute.
yeah, I have seen
Yes.
that.
Where they have filed an objection to my partition application, denying my title.
Uh, yes, yes.
Yeah, Dr. Bak said the court
No, no,
will
you have
follow
filed it.
that.
You have filed it. You have raised a title so far relating
Yes.
that on the basis of your objection, partition was refused,
Refused.
which the Board of Revenue said nothing doing.
Yes.
Give it there.
Give it.
This is you. Full stop. From the record, it is seen that the basic objection of the petitioner, who was respondent before the learned additional deputy commissioner, as to the entitlement and ownership of the petitioner as regards over the disputed land. That being the position, the best course of action would be to file and would be to relegate the aggrieved parties to a competent civil court to determine their ownership as well as title, ownership as well as possession. Full stop. In that view of the method, this court thinks it fit that the aggrieved parties, whosoever is aggrieved, or if you are happy possessing, he have possessing. The-
Without a partition, I can possess.
Okay, aggrieved party may approach the civil court for final adjudication of the dispute.
Appropriate.
Huh?
Appropriate.
Dispute.
Because he is living in Dibru.
Till then, we do not know. That is why we cannot. Even Board of Revenue cannot decide who is not.
Yes.
Uh,
Civil court subject matter. will-
The order passed by the Board of Revenue, impugn order dated so passed by the some Board of Revenue shall be subject to the outcome of any determination that may be made by the civil.
Obliged.
Unnecessary Board of Revenue are fighting.
Good.
I sense. Yes, Mr. Goswami.
It is the construction
Hmm.
of.
Who is for the respondent? This is subcontract and all, is not it?
Yes, that was part of the
Ah.
stuff. So there is no dispute. Because what has happened, that gas breaker project
Ah.
in Dibrugarh.
Ah.
It is a huge project. So we have the first parent owner, if we can say that,
Hmm.
that is called PCP.
Hmm.
Brahmaputra Crackers and
Polymers. Ah.
They have appointed EPI,
Hmm.
engineers.
Engineers Projects
Project.
India Limited,
They are the main
executing authority.
executive. Third team is not the primary contractor in this particular case. Respondent number 4,
Hmm.
NEF.
Hmm.
And we are the subcontractor. of-
Underdone.
There is a clause
Hmm.
which says that on their certification,
Hmm.
the money will be paid by EPL directly to us.
Hmm.
And we got it on that basis.
Hmm.
The first order of this court.
Ah.
So there is no problem. Actually, it is the last bid which is now in it.
Hmm.
And running bill free.
Hmm.
The certification has come.
Hmm.
That was the procedure. My principal, namely respondent number 4, has certified
Hmm.
that the amount which should be paid to him is 90.
Hmm.
All this project is over.
Ah.
Construction done, all verified, no dispute of any kind. So, if that certification comes, EPIL should pay up.
Hmm.
That is because
Ah, okay.
EPIL gets the money from the
Hmm.
PCP. Now they were withholding the money for no reason to move this court.
Hmm.
And
this court passed an order that don't pay directly to the
EPR, any
the-
FFS,
the-
NEPS.
NEPS,
mm.
because this money is due.
Hmm.
And the certification has also come from NEPS. Therefore, they should not
Huh.
hold the money. CIL has no business to hold our money like this, but they are not paying. And then finally we moved an IA before this honorable court because they already
IA.
said that the matter is pending, we will not pay. 1695.
Hmm.
There, Milord, the order is
So we need to take the IA part.
that
Isn't it?
is already directed, Milord. There is an order of 28/1/21.
Okay, who is the other side? BPCL.
What is it? Please take your consent, Milord. But I find it very strange.
Union of India.
This court, Milord, clarified
Hmm.
that it is in that very order, Milord, 28/1/21.
Hmm.
Disposing of that interim application. Had the Bora Learned Council for the petitioner also had Ms. R. Chakraborty.
So respondent number 4 also given. Only thing is the release of the money remain.
Absolutely, nothing else. And your lordship has said this last part.
Hmm.
In view of the above, it is your lordship
Now who will pay this amount? I want that council.
EPI.
Who is representing APL? Huh? Who is speaker? Inform Priyangshu. Mr. Goswami will take it up on Monday. Or even if you can, whether he is available, you do not know. Inform him, we'll either take it up because it's not, it should not be kept
Only
pending.
your lordship has seen that,
Uh-huh.
that order.
Then therefore we'll have an instruction, what is their stand and why they have not paid.
There is
Then
no-
we'll list this
they have
matter,
filed an affidavit without disputing any of the claims.
anything.
Nothing.
Because this is statutory kind of, this is a contract which includes payment directly to you.
Yeah.
It's not that without any
No,
authority
there is
subcontract is.
agreement between them, and that is accepted. No dispute, even in this order.
Hmm.
finally, there-
So what
there
to
is-
do, tell us.
you know,
today?
it was said that in view of the above, it is hereby clarified that.
Yes,
pending-
Mr. Bora, can you intimate him?
Actually, I told him and he was also trying.
You are sitting here, I thought some serious matters are there.
No, it is, I am surprised because so long they are holding.
This matter should not take so
No,
much
no,
of
it
time.
is absolutely
This is-
admitted fact. And the project.
Because
has
first order itself reflects everything.
everything. Clause 11. is
Everything
quoted.
reflects how it is. That order can, with that order, we can dispose of within a specific time to pay them.
Yes, sir. Nothing, I am not seeking anything else. So we'll try to protect it if your lordship can keep it for tomorrow.
Hmm.
Be
Ah.
available.
Then you make,
His
or if he is
presence
not
is-
available, make a mention in the morning, we'll fix it as for a convenient date. Mr. Bora, okay.
Your lordship will mind me not pick up tomorrow.
Tomorrow.
It may be taken up first if he is.
Okay, it will come in the orders. List this matter order in the orders column tomorrow.
We'll try. to-
Full stop. Tomorrow. In the orders, we'll decide.
Yeah.
It is need not come in the. It is very good. Interpret. Be online per day. Yes.
To us then allotted to
Yes. Joint verification.
But report they have. report
File?
they have- yes,
Where is that?
possibly it is not on the
Okay, list this matter on in the orders column on Tuesday.
not, my lord, I have
Okay,
so I
okay.
I
It is
did-
submitted that pursuant to this court's order dated 7/3/2024. No, pursuant to this court's order dated 6/2/2024. The report has already been filed by way of an affidavit. Full stop. The learned counsel for the petitioner submits that she may be granted some time to go through the report and complete her instruction from her client. Prayer is allowed. Please this matter. You tell us.
let it in the first week of February.
First week of
Even I have to take it
okay. First week or second week.
Sir.
Before Bihu.
before
Give a date before Bihu.
on 5th.
5th of
Sir.
April. There are some other methods also. This is not the only one.
Yes, one more case is there. That is related to another person.
Okay.
See, but
Okay, let us not mix up.
Look,